Blow the whistle with DJ Lilo.
Hello, 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 and welcome to another episode of Blow the Whistle with EJ Lee Law. I am your ref and attorney, EJ Lee of EJ Lee Law Practice, where the motto is to be referee whistle official. So we're just going to cover what we went over last week for our technical file number 1. As you guys know, we are going through the 12 technical files that I see most often in the IP game. So last week we talked about technical file number 1, which is what is the purpose of a trademark. The purpose of a trademark is to act as a source identifier for products and services. Trade and service marks ensure that consumers can find what they are looking for and creates a level of loyalty when the product or service is of good quality. The mark / logo / symbol or even a style must be tied to a product or service to function as a trademark. So before we get into it, I wanted to just go over a little bit so you guys can know a little bit more about EJ Lee Law Practice. EJ Lee Law Practice, LLC, is located in Metro Atlanta. We handle trademark and copyright registrations worldwide, adding patent soon, as well as drafting, reviewing, and negotiating contracts for members of the entertainment industry and Georgia's businesses, big and small. Yes, indeed. And so now we're getting into technical file number 2. Understanding the differences between IP. And there are different levels. We have our patent, we have our copyright, and we also, of course, have our trademark. So we're going to be going through those 3 things in this presentation before we get into our commentary with the beautiful Mackenzie. Just 1 second. Bear with me, guys. Gotta love technology. Before we get into it, let me send her this link really quickly. All right, so as I was saying, technical file number 2. Article 1, Section 8, Clause 8 of the U.S. Constitution states that Congress has the power to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. The founding fathers understood that to encourage invention and innovation, creators need monetary incentive before handing over their works to the public domain and ultimately for the public good. What is patent law? Patent is the granting of a property right to an inventor issued by the United States Patent and Trademark Office from a term of 7 to 20 years. Patent is the strongest IP in the United States. Essentially, a patent owner can exclude others from making or selling that invention, and licensees must license and pay royalties to the original inventor or licensor. In exchange for this exclusive right, they must list the claims or blueprint in the patent so that one skilled in the art may be able to practice, create, or put it together once the patent term expires. Patent examples include the vehicle, traffic light, television, refrigerator. Those are examples of utility patents that get the highest level of protection, which is about 20 years. Facebook and Apple, for example, have design patents. Facebook for the overall look of the interface that we see, and the same for Apple as well as with their interface. What is copyright? Copyright involves the exclusive right to print or copy, recreate, publish, perform, or display, and otherwise monetize one's creative works. Copyrightable works are original works of authorship, meeting the minimally creative standard and contained within a tangible form, i.e., a manuscript, film or television script, MP3, or MP4. Copyright applies to books, magazines, newspapers, digital courses, visual artwork, including logos, music, photography, films, television, choreography, unique furniture designs when they can act as separable art, websites, jewelry/clothing designs, and software. What copyright does not apply to: ideas or concepts that are not transferred into a tangible form are not copyright protected. For example, if you have a book or television concept, including characters, storyline, and plot, it is not copyright protected if existing as an idea only. A tangible form would be a manuscript or written in a notebook. Bottom line, do not share ideas with others without something tangible existing first. Copyright also does not apply to song titles, book titles, or short phrases, such as voice tags, which are common to prevent copyright infringement of music producer tracks and are generally not copyrightable alone because they do not meet the minimally creative standard needed for copyright protection. However, they can be protected as trademarks where attached to an additional product or service offering, such as selling t-shirts. Singer-songwriter Taylor Swift obtained trademark protection for a short phrase in one of her songs, "This Sick Beat," to be sold on merchandise such as graphic t-shirts and guitar picks. Unlike patent requiring an inventor to apply for it, copyright protection automatically attaches to original works of minimally creative authorship where contained in a tangible form. However, to obtain the full benefits of the law, authors are required to register the work with the United States Copyright Office. Registration serves as notice to others and is a requirement before a copyright infringement action could be filed in court. What is a trademark? A trademark is generally a word or words, logo, possibly a book, TV, or comic character, symbol or slogan, sound, color, created with the main purpose of distinguishing a business from its competitors within the same consumer product or service market. This is how our consumers find us. Unlike copyright, where the protection under the law is automatic, trademark protection requires actual usage or offering a product or service for sale to the public in connection with the proposed trademark, and then filing for protection with the United States Patent and Trademark Office in a specific protection class. Some creative works that are copyrightable can also serve as a trademark. This is where copyright and trademark overlaps. For example, Mickey Mouse is Walt Disney's minimally creative expression of a mouse. Thus, it receives copyright protection. Mickey Mouse is also associated with Disney's endless merchandise, such as clothing, posters, bedding, mugs, and numerous movies. Unlike copyright protection that will eventually expire, trademark protection is indefinite as long as the business maintains consistent and continuous usage of the mark with the associated products and services. Got additional questions? Subscribe to our newsletter via our website, which is www.ejleelawpractice.legal. You can reach us at our email, which is contact@ejleelawpractice.legal. We also have our phone number, which is 678-343-2799. You can also follow our Facebook page, which is Be Creatively Legal with EJ Lee Law. We have Twitter and Instagram, both under the handle of EJ Lee Law. We also offer affordable DIY courses under Referee Whistle Official, and the next one is taking place this Saturday on April 17th at 6 p.m. via Zoom webinar. All those links will be left in the description box for you guys to check out later. And now it's time for what's happening in these IP streets with Mackenzie. And just give me a second as I get ready to invite her on. I'm sending her the link, you guys. Eventually, we're going to do these broadcasts live, but in the meantime, we're doing them pre-recorded. So just let me know how you guys like everything. And like I said, we're going to get better. What's happening in these IP streets? Oh, while I'm waiting for her to come on, like I said, we also have our DIY trademark course, which is taking place this Saturday. So I'm going to allow you guys to see that little video about the upcoming course.
Hello, attorney EJ Lee here. Trademarks are the first thing that people recognize about your business. However, many startups and entrepreneurs do a limited budget delay the intellectual property registration process, which often leaves them legally vulnerable. Introducing Referee Whistle Official Live Webinar, an exclusive one-day event to get you off the idea sidelines and into the game. Referee Whistle Official Live Webinar is a monthly invitation-only event for entrepreneurs, brand builders, entertainers, authors, and creatives ready to dive into the art of intellectual property protection. Are you ready to register your trademarks but unsure exactly how to do it? Our live one-day session downloads the skills and strategies necessary to identify, protect, and manage your intellectual property so that you develop a worthwhile legacy. You will receive a step-by-step instruction workbook, live instruction from yours truly, and time to ask questions. Sign up for the webinar now at the link or leave your email to receive upcoming webinar dates, discounts, and more.
Yes, you guys. So we have the upcoming Referee Whistle Official. All right. And now we're in our segment of what's happening in these IP streets with the lovely Mackenzie. And I'm inviting her on to let us know what's going on in these IP streets.
I'm on. There I am.
I love technology, right?
Yes. I wanted to discuss today a couple things that I had noticed on social media. One of the things that I had noticed was with Microsoft and having a contract with the Army for some software to do mixed reality headsets for soldiers.
Interesting. Okay.
Yeah.
All right. Now, why do our soldiers need virtual reality, I guess?
You know, I think it's a really good thing because I think, you know, a big industry right now is the gaming industry, and everyone knows that a lot of these video games are based off of simulators. So, I mean, even with the drones and probably some of the software that they already have for things for combat and military and weaponization and things of that nature, I kind of just feel like this is, although this contract is newish, newer, it was really interesting that Reuters have reported that the contract could be worth, you know, almost $22 billion over the in the next 10 years. I'm sorry. But I wish this was something that was more innovative, because I feel like this has been around for a while already. I don't think
Okay.
it's uncommon knowledge that, VR and things of that nature are being used in a lot of these industries,
Okay.
especially when it comes to globalization, and not wanting to be maybe as hands-on in combat and things of that nature, and learning how to use AI software simulators to still accomplish those things. So I do think it's interesting that Microsoft is a more well-known brand that we all know. So I think it's interesting that we kind of know the players, in
Right.
this type of technology. But I think it's unfortunately kind of predictable.
Predictable how?
Because it's Microsoft, it's a tech giant. They're going to want to get their hands in anything they can.
Well, this
That
has
they're
been a
going to.
year of government contracts for sure, because obviously we had a number of companies signing up in terms of coming up with the vaccine in a record amount of time that they have.
Yes.
I'm just curious as to whether or not Microsoft will maintain ownership of this technology or whether it belongs to the government. That was kind of one of my thoughts. Like, I'd really like to see that contract, because, obviously the government, in most of their contracts, I would assume the government wants to own it. But if I know anything about Microsoft, most of the time you're getting a license. So
Right.
I'm
Very
going to
true.
assume this is going to be an ongoing contract. This is not going to be something that is just going to be like a one and done, like you said, because this has been around for a while, not necessarily in the military space.
Right.
But I do wonder, again, how this is going to, I guess, assist them in, I guess, making better decisions in terms of, like, for instance, we're dealing with police, right? And all of this unrest in terms of training and de-escalation, and how maybe this can be used in that way to teach them de-escalation situations versus always, oh, I forgot, I meant to grab my taser. How are you confusing your taser for your gun? I just don't know.
That's
So how, Sway? The thing,
I don't know.
from my understanding, I've never held one, but from what I've been told and what I've read is that tasers are a lot lighter than your gun. Secondly, it's bright yellow. Also, I was just thinking, okay, if this young man, obviously we're talking about, I believe his name is Durante, right, who was unfortunately killed in Minnesota behind a traffic stop. That the young man was trying to get back into the vehicle because I guess the police informed him that he had a warrant for his arrest. I don't know whether he was already in the vehicle. I refuse to watch the video. I'm not into Black trauma. I don't know about you. But the point of the matter is, why would you, whether it's be a taser or a gun, why shoot at someone that's going towards a vehicle with someone else in the vehicle? Secondly, able to take off in the vehicle and be able to harm other people if he's able to operate the vehicle. To me, it just doesn't make any sense. You've already got his license. You've already got his license plate number. You can get him another day. Like, what does it really matter that you have to get him today? Did he kill somebody? Like, I'm kind of over it. And I know we're going off in a tangent and we're supposed to be focusing on the IP streets, but I would like to see how this technology can be used in a way for de-escalation instead of what we're constantly dealing with, where there's just overwhelming overreaction. And then we're like, oops, sorry. And someone's loved one is dead. So yeah, it's just unfortunate. So I'm hoping that it can be used in that way, because we've heard of stories where the military has gone over in other countries, and then they come back home like it never happened. And then we're hearing about it years later of people that they've harmed because they simply did not have the proper training. And hopefully this is some way to deal with some of those things. So you're not so quick to pull your gun. There's some kind of judgment calls that we can get from this. So that's what I'm hoping for, that technology.
I agree. I think it's just, unfortunately very lucrative to have a lot of these prison systems, also, because of prison labor, and privately owned, prisons. I think also it's difficult, I feel like, for some of these really tough issues to be assessed and to be remedied. I think it's also a case-by-case basis when it comes to some of these police departments and police officers, because they're not all bad,
No, they're not.
It's really unfortunate that, some of these serious issues happen because there's no one thing fits all,
Right.
but I definitely
And we need the ones who recognize that they are not bad to speak up for the ones that are,
yeah,
So
absolutely.
Martin Luther King has said plenty of things in regards, I'm paraphrasing, that it's not so much that, bad is out there. It's just that good people don't speak when they see it. You're profiting from not saying anything. We have to change that behavior. If you see something, you have to speak up. And so a lot of times, if you notice, we're pairing young officers with senior officers, and because they look up to those officers, they don't feel like they have the authority to say, no, what you're doing is wrong. My police training has told me that that's the wrong thing to do. The 2 officers that were involved in the George Floyd situation, those officers were not even a year in the force, and they're with this senior officer basically doing whatever he wants to do. What are they supposed to do? I don't know. They have to definitely change that to where I don't necessarily think it's a good idea to pair young officers with senior officers. If those officers, especially if they have a reputation, this particular officer had a reputation going a mile long. You know what I'm saying? So we don't want to make this too heavy, but you get where I'm going with
Right,
this.
absolutely.
What's the topic? Hopefully something that's a little lighter.
Okay, so I know that, we were emphasizing the importance of the differences between trademark, copyright, and just the different, tech terminologies and ownership when it comes to IP. And so I had read that there's a company of 3 Oakcrest High School friends who had started this supplement, and they used I believe, I'm not quite sure who Gal Gadot is, and I don't know if that's a good thing or bad thing. So I apologize to viewers.
From Justice League? Is it Gadot?
Yeah.
Yes, that's the actress from Justice League. She plays Wonder Woman.
Okay. Then you are my saving grace. Thank you so much. I don't watch TV like that. I don't watch movies. I'm working on it.
Okay.
Anyways, so basically there's a dispute going on right now because these 3 high school friends had created a line of supplements, and they didn't know that they would, end up disputing with this actress and her name and their supplements. So it looks like she herself is also coming out with some sort of supplement launch as well that would be called Gal Power or something to that nature, regardless, incorporating her name and her likeness. And now there's, these 3 high school friends that are now grown, but they have their own supplement line too. And it's, using kind of like it's somewhat to her likeness towards a dispute. And so I wanted to just emphasize, your take on that being, ownership is everything, and having the application and the filing and all the procedural paperwork is everything when it comes to keeping, your business, your brand, your product, your service to your, own liking and to your own benefit. So I thought it was very interesting.
I want to make sure I have this correct. So these 3 high school friends, so they're not in high school now. They're grown, fully grown. Okay. But they wanted to use Gal Gadot, I don't know if I'm pronouncing her name right, Wonder Woman, the lady playing Wonder Woman. They want to use her likeness on the supplements. Is that what we're saying?
It looks like what they did was in specific, and I'm going to read my notes. So please
read your notes, please.
So it looks like they did something called power supplements, but it looks like I'm trying to see what the relation is regarding both of these 2. I think it's just 2 supplements, and I think let's see, it's Power Rush. It's a lot of the similarities in maybe the marketing or the advertising. And so she's coming out with her own supplement line, which has very similar, it's Gal Power. It's a PWR kind of theme that they have.
Got you. Okay, so it looks like what was happening is there's a fight over the name that they're using. Because I would like to think that they wouldn't be crazy enough to use this woman's likeness without her permission. That would just be crazy. So I'm assuming like there's an overlap in the name that they're using. So what I try to tell clients is to make a list of all of the terms that are commonly associated with what it is that you're doing. And if it is, throw it away. Or try to use it as the secondary piece of it. It's not the main name, because a lot of times you're going to get in these situations where you're fighting over those terms with other companies. And depending upon how long your budget is, you can fight it. Or if your budget is this small, you might not want to fight it, because I'm going to assume that Gal Gadot has the money to fight for this supplement name versus they might not have the funds. And so power or anything to do with strength, slim, bulking, those types of words are associated with supplements. And so it just means that your competitors have a legitimate reason to want to use those words. And like I said, it's going to be a matter of who has the most dollars and whether or not the USPTO would even grant a trademark registration for something that they feel might be too descriptive of what the product is talking about providing. So that sounds like what the situation is.
Yeah, so, I agree. I just know that it's super important. Like, get that application in, just get the paperwork done so you can have
preliminary approval if you can.
Last week. Yeah.
You can get preliminary approval and avoid having to spend all of this money on marketing dollars and then have to scrap the entire thing. It's better to get pre-approval if you possibly can, or even again, checking in the records to see what other people have filed for, because maybe they just didn't realize that Gal Gadot had already went after this and it would have said, okay, well, let's go for something else. So avoid this route.
Yeah. I do think in this case, the Friends had a longer record, of the common trademark or the common.
Oh, the common law?
Mm-hmm.
Gotcha.
So they have one aspect as far as the length, and then she has, the application and,
and the money.
And the money. Absolutely. And the money.
At the end of the day, it's all about budget. I don't care how long you've been out there. If you're a small fish, you're a lot of times going to get fried. Again, a great example is Burger King. There was a couple in Illinois. They had Burger King long before the big Burger King came along. But Burger King contacted them and said, hey, we're getting ready to file for the trademark registration. So, of course, that company, that couple went scrambling, trying to figure out how to get the trademark registration from Burger King. And so the outcome of that was that Burger King, the big corporation, obviously got the trademark registration, but that couple was basically locked into where they had established themselves within that geographical area. And so they operated those two Burger Kings within this small Illinois town for about 60 years before they went ahead and retired. Because their kids didn't want to take it over. So Burger King couldn't stop them from operating because they had the common law rights and they had been operating continuously and consistently for a number of years before Burger King came along. However, as we've talked about before, if they had the trademark registration, it could have been an asset they could have used as leverage to get Burger King to buy it from them for millions of dollars if they really wanted it. You know what I'm saying? Mm-hmm. I will rebrand all day if you give me enough money to retire.
Right, absolutely.
Absolutely. So there's that. All right, moving right along. What's our next topic? Good job so far. I love it.
Thank you. Let's see. What is something else? Well, what have you been seeing on Twitter?
Well, as of right now, what we've been seeing is people are upset about the coverage over Prince Philip. 150,000 people in the UK sent in complaints about the over coverage of Prince Philip. They're like, we don't care about Prince Philip. We just want to watch our shows. So
that's a lot of people. I wonder what the, what the royal family feels about that.
I mean, come on, let's just be clear. The millennials, whether you're here in the United States or in the UK, do not care about the royals that much anymore. And I think as every generation goes on and we're further removed from where they have any kind of political power, they could care less. That's what I think. So, okay, he died. Girl, what we having for dinner? That's basically how that went.
Right.
So yeah, that's what I'm seeing in the streets. The other thing I'm seeing in the streets is this debacle over Usher and the Usher Bucks.
Okay, I briefly saw that on Instagram. What did you get? Tell me the details on that.
Okay, so I have to do better about making sure I research stuff. But basically what happened is a stripper posted a picture on her Instagram page, basically showing that Usher and someone in his team threw Usher dollars in the air, right? Instead of actual money. And so it's a $100 bill with Usher's face on it. It's a $20 bill with Usher's face on it and a $1 bill with Usher's face on it. So she basically made this whole rant about that. Apparently being in the club, of course, it's dark. He's making it rain, but it's not real money. It's actual Usher dollars, right? And so, of course, it was trending on Twitter. But Usher's camp later came back and said that they did spend money, that the money as far as the Usher bucks was left after the fact as a joke. but they did break actual real dollars. And so it was a joke, but I'm just like,
why?
I don't know. It was to promote his upcoming Vegas residency that he has coming up. Child, I don't know.
I think a different approach to promoting, with these, printed currency dollars could be like, maybe your, VIP or your people who purchase your tickets can get these Usher bucks and have different incentives. I think when people know that they're getting Usher bucks,
Right.
it's a whole different narrative than if somebody is working and receiving pay for services, and it's like bubble money, from SpongeBob. You know what I'm saying?
Listen here. They say they broke money, and I figured that was the case because I highly doubt that Usher would have been able to leave. Most of these clubs, especially in Vegas, have bouncers bigger than Andre the Giant. So I just imagine that wouldn't have happened, but it was just funny to see the money with his face on it. And I'm just like, first of all, real money feels completely different from paper. So I wonder what the consistency of it was.
I'm a big fan of Usher.
Oh my God. I cannot.
I think
I've had so many
do no wrong.
Man.
I think he can do no wrong, but I think this is a wrong.
But they came back real quick. Like, no, Usher didn't do that. It was somebody in his camp. And I'm just like, well, they probably should have cleared it with you first, don't you think?
Yeah, I just would like to know, I would buy Usher bucks. I think that's cool. I think it's more novel.
But I mean, I would definitely want one as a souvenir. You can give me one at the show.
Novel. Yeah.
Not while I'm stripping and doing my work, though.
No.
No.
Time and place.
Yeah, time and place. And then obviously, lastly, people have been talking about the over coverage of DMX and how the media is too quick to want to be the first to report before allowing this man's family to be able to report his death. It was just like everybody waiting by their computer, like, he died yet? Like, damn, can you let people do it themselves? It's just crazy. So that's basically what I've been seeing in the streets, obviously. So no one has time for I guess focusing on the IP stuff just yet. And for us attorneys, as of right now, it is CLE time where we have to get our continued legal education classes in. So that's presently where I'm at, trying to get that done. So we have to do 12 credits every year as part of our requirements as Georgia attorneys. But it looks like that's what's happening in these IP streets. We thank the lovely McKenzie for always keeping us informed of what's going on out here. Absolutely. And it is another episode of Blow the Whistle.
I didn't get my whistle.
You gotta get a whistle. It's fine. But I implore you to get one for the next episode. And that's a wrap, y'all. We're going to be coming back to you with technical file number 3. I have to go back to list to see what exactly technical file number 3, but you'll know when it's time. So we love you guys, and we thank you for always joining us on another episode of EJ Lee. Blow the Whistle with EJ Lee Law. Y'all know how this goes. We out.